Let me ask you about another case. Is it the position of the United States that the states lacked standing in the Little Sisters of the Poor case from 2 years ago because their expected additional health care spending was an indirect injury?
Justice Alito, I can't recall whether the government made standing arguments in that case.
Well, I'm just asking you now. What do you think about that? The argument was that the states, Pennsylvania, I believe, and another state had standing because the regulation they were challenging would have the effect of imposing, it would remove health care from certain residents, students who were away at college in other states, and thereby impose an additional cost on the states. Was that wrong?
So if I understand the facts of the case correctly, I think that it's possible that that would constitute the kind of direct injury that this court's precedents have recognized in this space if the challenged regulation operated directly on the states with respect to dictating, for example, their federal funds or requiring regulating them directly.
No, they just said that they would have to pick that up under state programs. Well, let me move on to something else. On this indirect, direct injury distinction that you're drawing, should we hold that an indirect injury is never injury in fact for Article III purposes for all plaintiffs?
No, we're not asking for that. So we think that this is a distinctive principle that the court has applied when states are seeking to vindicate sovereign or quasi-sovereign interests. And the reason for that, I think the reason the court's precedents recognize that the states are then under an obligation to show this form of direct injury is about our constitutional structure. It's
so
about
this is a special standing rule for states that disfavors state standing.
Well, let me be perfectly clear that when the states are seeking to proceed on the basis of proprietary harms, the same kinds of interests that other private litigants can bring, we think that the same rules apply.
Yes, but an injury that would be sufficient for Article III purposes for an individual or for a private entity is not sufficient, in your view, for the states. There's a special rule for the states.
With respect to quasi-sovereign and sovereign interests, yes. And the reason that
so this is a rule of special hostility to state standing. How is that consistent with Massachusetts versus EPA, where the court said that there is a special solicitude for state standing?
Special solicitude, as we understand it in this court's precedents, reflects the fact that states have more theories of injury available to them. So they're not limited to the same proprietary interests that other parties can assert with respect to their contract rights or being regulated as an employer. Instead, special solicitude reflects the fact that states can also seek to proceed on the basis of sovereign or quasi-sovereign harms. But I don't think it's right to suggest that the court's rules or framework in this area amounts to hostility. This is about recognizing that when one sovereign is suing another sovereign under our constitutional structure, that implicates fundamental constitutional principles. And I think a contrary rule would effectively mean that states can sue about anything.
You don't like the word hostility, but you have a special rule for state standing that disfavors the states. The states are in a less favorable position than they would have been if they were a private entity or an individual. Let me move on to one other case. Do you concede that Federal Election Commission versus Atkins acknowledges that Congress can permit civil actions challenging non-enforcement decisions?
Yes, in that case, I recognize that the court concluded, obviously, over Justice Scalia's dissent, but that is an example where the court allowed standing in that circumstance.
And why doesn't that principle apply here?
Well, I think that the more on-point precedent in this case is Shurtan, where the court specifically took the Linda R.S. principle and said that it applied in the realm of immigration law as well.